You and I have on previous occasions discussed the CEO pay ratio provision I authored in the Wall Street Reform Law, which requires companies to disclose the ratio of compensation of their chief executive with the pay of median workers. This measure focuses investors' attention on the relative value a CEO creates in order to facilitate better checks and balances against insiders paying themselves runaway compensation packages. And while CEOs undoubtedly can create value for companies, so can ordinary workers across an organization. So when a CEO asks for a raise while giving other employees a pay cut, investors should have this information so they can ask whether this is a value creation or simply value capture by insiders, especially in an environment in which incomes for the top 1% have grown by more than 86% over the last 20 years, while incomes for everyone else has grown by less than 7%. As you know from my letters of support, I was pleased to see the SEC's proposed rule last year to implement this provision, which in my view accurately reflects the legislative intent that I and others intended. Can you please give us an update on the status of this rulemaking, and when does the SEC expect to finalize it?
Essentially, as I think I said in my oral testimony, we are focused the balance of this year in terms of our Dodd-Frank mandated rulemakings on Title VII and executive compensation. Pay ratio is one of those that has been proposed but not adopted. It is certainly a priority to complete it this year.
So it's your expectation that you would complete it this year?
It is my hope and expectation to complete it this year. The staff is still going through the comments, which were extensive, and formulating a final recommendation, but that is my expectation.
Okay, I hope there will be more expectation and less hope. Now let me turn to Chairwoman White. This summer, the SEC received its record 1 millionth public comment supporting a rule to require public issuer companies to disclose their political campaign spending to investors. Supporters include leading academics in the field of corporate governance, Vanguard founder John Bogle, investment managers and advisors, and the investing public. Without disclosure, corporate insiders may be spending company funds to support candidates or causes that are directly adverse to shareholders' interests, without shareholders having any knowledge of it. The amounts being spent may be small or large, but shareholders have no way of knowing. And even where the amounts are small relative to the overall size of a company, the impact on an election and therefore on shareholders can still be very large. If corporate political spending is material to investors, as the leading experts in the field and over 1 million members of the investing public believe it is, why isn't the SEC requiring public issuer companies to disclose this information? Do you have any plans to engage in a rulemaking on this issue anytime soon?
As you know, we have two petitions actually still pending before the SEC to require such disclosure. If in fact in a particular company the political spending is material under the law, that would, under the law, be required to be disclosed now. The petition is broader than that. Again, as I believe the Senator and others are aware, we're very focused on our mandated rulemakings under Dodd-Frank and the Jobs Act. The staff is currently not working on a proposal in that area. I do note that a number of companies have voluntarily made those disclosures, and that subject can also be, and often is, a subject of a proxy proposal.
Well, I appreciate where you said your focus is, but when 1 million, I think it's very rare that you get 1 million public comments in support of a proposal. And even if you look at Justice Kennedy's majority opinion in Citizens United, which opened the floodgates for corporate election spending, and that presumes that shareholders should have transparency, it presumed, in his opinion, that shareholders would have transparency in order to enforce accountability over executives. So how is it that investors have control, have that transparency, if they can't even get basic information about what is being spent?
I appreciate the intense interest of investors and others in this issue. I mean, clearly the comment letters, there have been many. They have been on both sides, and it is an area that I'm quite sensitive to, that it is of high interest. But as I said earlier, at this point in time, it is not part of our current regulatory agenda. We are focused on the mandated rulemakings.
Well, I appreciate that as someone who is here and helped not only devise Dodd-Frank's but also supported it. I'll just close on this comment. You know, I would hope that this is true across the spectrum, that all of you realize that while you may ultimately deal with significant corporations in this country, that at the end of the day, it is the public who we collectively seek to serve. And that is best served by transparency and openness and an opportunity to understand what companies are doing, whether that's CEO pay to worker pay, or whether that is using potentially millions of dollars of corporate funds to maybe the disadvantage of the very investors who are investing in that company. And so I hope that the hallmark of what we can expect from all of you, but certainly in this case where you have some particular unique jurisdiction, is a push towards greater transparency so that investors really understand what choices they are making and whether the company is best serving them. Thank you, Mr. Chairman.